Okay, well, welcome back, everyone. As we've mentioned, yesterday we were speaking primarily about the evidence for the effectiveness of various approaches to gun violence prevention. And today we're talking more about how to make some of those things happen. And obviously you heard in the morning panel the lessons that could be learned from countries other than the United States. And this afternoon we'll have two presentations that also affect actually our ability to make change. The legal issues that are associated with our ability to make that change and the public opinion issues. So for our first presentation, it's my great pleasure to introduce Professor Adam Winkler, who is a professor of law at UCLA Law School. He's one only has to read the newspapers since the most recent shootings, and frankly before that, to see that he's one of the most widely quoted, one of the most prolific writers on the issue of the Second Amendment and what its scope and application to gun violence prevention are. His book, Gunfight, is also available, and we're just very, very pleased to have Professor Winkler here today. Thank you.
Well, thank you very much. I want to begin, first of all, by acknowledging and thanking my co-author, Larry Rosenthal, who really should be up here giving this talk instead of me. He is certainly one of the great emerging voices, insightful and influential on the nature and the meaning of the Second Amendment in the wake of the Supreme Court's recent decision. So thank you, Larry, for writing this with me and joining me in this effort. I also want to thank, of course, the organizers, Jan and Daniel, and everyone from the president of the university on down to the staff, Susan Murrow and whatnot, that has organized a terrific, engaging, and hopefully impactful conference. I'm not going to talk with any PowerPoints today because as a law professor, I don't like the attention to be anywhere else but on me. And I'm here to talk about the Second Amendment to the U.S. Constitution and what it says about some of the major reform proposals that are being considered in the wake of the Newtown Massacre. As you all probably know, the Second Amendment to the Constitution provides a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. It's almost as if James Madison, the author of that provision, had just discovered this wonderful new thing, the comma, and wanted to put it in there as many times as possible. And ever since he did that, this amendment has confused generations of Americans as they've sought to figure out what exactly was meant by this rather cryptic amendment that is beset with all of these commas, breaking up what seems to be singular ideas. A sure sign of this confusion over the nature and meaning and scope of the Second Amendment comes from a lot of the public statements we've seen since President Barack Obama said that it was time for meaningful action to reduce gun violence. Because what we've seen is many people taking to the airwaves and the blog sphere and the Twitter sphere, arguing that the President is preparing an assault on our Second Amendment rights, and that the kinds of laws he's talking about will do away with the Second Amendment or be major infringements of the Constitution. I call this confusion because many of these people apparently haven't been reading any of the court cases that interpret the Second Amendment to the Constitution and tell us what exactly it means. In fact, as Larry and I argue in our contribution to the Summit on Reducing Gun Violence book, that most of the most popular reform proposals being considered today are all likely constitutional. That's not to say there's not any questions about any of them, but they're all likely to be upheld by the Supreme Court should they be enacted. From universal background checks to restrictions on the sale of high-capacity magazines, and even perhaps a ban on assault weapons, we think that it's likely that the Supreme Court would likely uphold all of these provisions. Now, in defense of those who do seem confused about the nature of our Second Amendment rights, in fairness, the Supreme Court has not really done its job of clarifying exactly what are the scope of our Second Amendment rights. As most of you surely know, in 2008, the Supreme Court held, remarkably for the first time in a clear and unambiguous case, that the Second Amendment protects the right of individuals to have guns for personal protection. 2 years after that case was District of Columbia against Heller, it struck down a law in Washington, D.C. that banned handguns and basically made it unlawful for you to use a long gun, a shotgun or a rifle, for self-defense. 2 years after that case, in a decision called McDonald versus City of Chicago, the Supreme Court held that the Second Amendment similarly applied to state and local governments and effectively declared Chicago's ban on handguns unconstitutional. Now, advocates in these cases asked the Supreme Court if it was going to embark on this new jurisprudence, this new clarity about the Second Amendment, to make it clear exactly how courts should go about interpreting the Second Amendment and applying it to other gun control laws. It's one thing to identify a right in the Constitution, but where the rubber hits the road in constitutional litigation is figuring out which laws are constitutional and which laws are unconstitutional. And so they asked the Supreme Court to adopt clear standards for courts so that they can apply the Second Amendment in the tidal wave of lawsuits that was sure to come if the Supreme Court found an individual right to bear arms. Well, the tidal wave came, but the clarity did not. We've seen a huge number of cases since the Heller case was decided, about 300, a little bit more than 300 federal court decisions on the constitutionality of a wide variety of gun control laws since 2008. And the court in Heller, though, refused to articulate this clear standard of review and said, we'll sort of address the questions as they come about. But the Supreme Court, nevertheless, did provide some guidance as to the nature and the meaning of the Second Amendment and how to approach gun control questions. The court clearly said that the right was not a right to have any gun, anytime, anywhere you wanted. It was not, as some people in the Second Amendment community believe, a libertarian license for you to have whatever gun you choose to have whenever you want it. Like any other constitutional right, the Supreme Court made clear the Second Amendment is, quote, not unlimited, end quote. And looking at history and tradition as guideposts to understanding the Second Amendment, the Supreme Court recognized that many gun control laws have been upheld under this amendment or state analogs over the course of American history. For instance, the court pointed out that a majority of courts in the 19th century upheld restrictions on concealed carry of firearms. The court also said that not everything that can be considered an arm in common parlance was an arm protected by the Second Amendment to the Constitution. Protected arms include only those weapons, the court said, that are in common use for lawful purposes, not dangerous and unusual weapons like machine guns. And in perhaps the most important paragraph in the Heller decision, the Supreme Court said that nothing in the decision should be taken to cast doubt on long-standing prohibitions like prohibitions on the possession of firearms by felons and the mentally ill, restrictions on guns in sensitive places like schools and government buildings, or conditions and qualifications on the commercial sale of firearms. When you think about it, that captures probably the majority of America's gun control laws. The court said that all of these laws are presumptively lawful and pointed out, too, that this list was not intended to be exhaustive and that there were other presumptively lawful measures that lawmakers can take. With this somewhat limited guidance, the lower courts have confronted this tidal wave. I mentioned the over 300 cases to date. Only a small fraction of those cases, federal court cases to date, have invalidated the challenged laws. The vast majority of gun control laws have been upheld. And relying on the Heller and McDonald decisions, we're seeing an emerging framework for analyzing gun control laws that has become the norm in the majority of circuits that have addressed this issue. And it's essentially, the courts undertake what is a two-step process in analyzing the constitutionality of a gun control law. The first question is, they determine if the particular law that's being challenged, if that burdens activity that's within the scope of the Second Amendment. The court said that the core of the Second Amendment right is a right to have a functional firearm for self-defense in the home. Not every law that burdens one's ability to have a gun in the home, however, can be said to fall within the scope of the Second Amendment. For instance, bans on felons or the mentally ill that the court said are presumptively lawful. Well, those obviously restrict the ability of someone to have a gun in their home for self-defense, but the court says that, or suggests at least, that those, and the lower courts have held quite explicitly, that felons and the mentally ill are outside of the scope of the Second Amendment. They don't have a right to have a firearm in their home for self-defense. They're outside of the Second Amendment. We might also think of courts have universally held that restrictions on guns by possession of guns by people with domestic violence misdemeanors or under domestic violence restraining orders are also constitutional. Many of those courts have said that those people are, like felons, outside of the scope of the Second Amendment, and so the law does not burden Second Amendment rights at all in these cases. We also might think of restrictions on machine guns or silencers, which are not thought to be arms under the purposes of the Second Amendment, not typically used for self-defense purposes, for instance, and thus not subject to Second Amendment dispute. If some activity is regulated by a law, like a ban on silencers or a ban on machine guns, and it's determined to be that that activity is beyond the scope of the Second Amendment, then the law is upheld. It's not invalid under the Second Amendment, and the case is over. If, however, a law does burden activity that's within the scope of the Second Amendment, the courts then ask a second question. And they ask the question is, how severe is that burden? And then as part of that analysis, they determine whether the law is adequately justified and sufficiently well designed to serve the government's ends. So this step two, in a way, has two steps too. A weighing of the burden, figuring out how severe the burden is, and then an analysis of the ends and the means. What are the ends served by this law, and is the law well designed to serve those means? So how severe is the burden? If a law effectively nullifies the right of a person to have a functional firearm in the home, and that person is protected by the Second Amendment, unlike felons or the mentally ill, then it's likely invalid no matter what. So we've seen handgun bans in Washington, D.C. and in Chicago struck down. These are arms protected by the Second Amendment. And as they apply to law-abiding citizens, a law that restricts or bans people from having access to those weapons is unconstitutional. We might think of other potential laws that fit this category, very severe burdens that are per se invalid, maybe restrictions on having firearms in public housing, likely to be the kind of law that courts would say is a severe burden on Second Amendment rights and likely invalid. If the law goes to the other extreme, however, so take a law that burdens activity within the scope of the Second Amendment, but very, very minor burdens, not a significant burden at all, the court would say, well, then it's likely that the government does not need especially strong reasons to uphold such a law. These might be thought of as incidental burdens. It's often the case in constitutional law that you can restrict a right with what are known as incidental burdens as a way of ensuring that those who exercise the right are entitled. So sometimes you'll hear in Second Amendment debate, well, that's not how we treat the First Amendment. But think indeed about how we treat the right to vote or the right to marry. Both fundamental rights protected by our Constitution. The Supreme Court says nonetheless that you can require people to register so that they can vote. You can require people to get a license before they get married. These are incidental burdens, the Supreme Court says, don't really stop people from actually exercising the right to vote or in getting married. Where there's law is just an intermediate burden, very little justification has been demanded of lawmakers. The vast majority of gun control laws, however, fall within a middle ground, where they're not a severe burden, like a complete ban on handguns, and they're not an incidental burden. They fall within this middle range, and courts basically say that where a law does burden and is a reasonably considerable burden on Second Amendment activity, then courts will apply what they call intermediate scrutiny. Now, constitutional law has a variety of different tests that we use to test challenged laws. Intermediate scrutiny is a popular one used commonly in the First Amendment, used throughout constitutional law in other areas. It basically asks two questions. It says, for this law to survive, it has to substantially further a government interest. So that breaks down into two things. The government interest has to be an important governmental interest, and the law at issue has to substantially further that interest. So the vast majority of gun control laws have no difficulty whatsoever meeting the requirement that there be an important governmental interest. Right? The important governmental interest justifying most gun control laws: public safety, reduction of gun violence. Easily, these are some of the most compelling, important governmental interests that the government can have, and as a result, when intermediate scrutiny is applied, even to considerable burdens on one's right to have a firearm for self-defense, the first prong of intermediate scrutiny is easily met. To answer the second question, the one about fit, does this law substantially further that interest in public safety? Courts generally look to see, did lawmakers have evidence, adequate evidence to support the idea that this law would further public safety? That's why so much of the work being done at this conference is important for what happens with regards to gun control in the future. We've already seen in New York, one of the houses today already passed a major gun control law. I'm sure it will be challenged in the court under the Second Amendment. And it's the research that's produced by scholars like those gathered here today that helps satisfy the courts that there is a substantial relationship between a particular gun control reform and reduction of public safety. So how does this emerging framework apply to the major proposals that we have been considering or are likely to be proposed as part of a new wave of federal proposals? Well, first we might think of universal background checks. Closing the so-called gun show loophole. As we've seen, it's not a gun show loophole, though. It's a private sale loophole that allows person-to-person sales to occur without a background check. There are proposals to require that every single sale or transfer of a firearm be undertaken with a background check. So, does this burden protected Second Amendment activity? Not likely. This serves as a simple screen that is used to see who is entitled to exercise this right and who is not entitled to exercise this right. Very much equivalent to what we see with the right to vote, to require people to register in advance. And the burden is most likely to be held to be, if any, merely an incidental burden, just like registration requirements. Especially with the NICS instant background check system, it is not a severe burden on a gun purchaser to go through a background check. It happens very quickly without much trouble. And moreover, even if the burden is thought to be somewhat more severe, that this law is well-tailored, well-designed to deprive criminals and the mentally ill of easy access to firearms. Imposing this requirement at the point of sale also matches up with the Supreme Court's recognition of the legitimacy of laws imposing conditions and qualifications on the commercial sale of firearms. What about assault weapons? Well, to determine if assault weapons are arms protected by the Second Amendment, we need to know if these firearms are, quote-unquote, in common use, or whether they are dangerous and unusual weapons. That was sort of the dichotomy set up by the United States Supreme Court. If they're in common use like handguns, then they're likely within the scope of the Second Amendment. We'd have to move to the second step of the analysis. If they are dangerous and unusual weapons like machine guns, however, the analysis would probably stop right there. Assault weapons like AR-15 variants are pretty commonplace these days. They've become very popular firearms in the gun rights community. They aren't, however, there are apparently tens of millions of these firearms out there, so arguably they are commonly used. But one possibility is that while these weapons are common, they aren't commonly used for the core purposes of the Second Amendment, namely self-defense. They are poor self-defense weapons, hard to maneuver in tight spaces of a home, and their projectiles are propelled at such a rate that they're likely to pose dangers to people as the projectiles go through walls, endangering family members or neighbors. If that's right, then assault weapons would not be thought to be within the scope of the Second Amendment. Yet I should admit that when Larry and I were writing this, we talked about extensively that there are some reasonable arguments that you can make against an assault weapons ban. An assault weapons ban, by one reading, Heller says, the District of Columbia against Heller case, says that a gun is in common use if it's used for any lawful purpose, not just self-defense. If that's the case, well, these guns are generally used for lawful purposes, sports shooting, for recreational shooting, lawful purposes. And also an assault weapons ban might not satisfy the demands of fit might not really substantially further the government's interest in public safety, given the studies that suggest that these are rarely used in crime, and that at least if the law that's adopted now mirrors the 1994 federal assault weapons ban that was pretty notorious for its loopholes and allowed the manufacturers to just produce pretty much the same weapons, just without the pistol grip and the bayonet fitting, then I think the government could have some difficulty defending such a law. I should say that the highest court in the country to consider an assault weapons ban to date was the U.S. Court of Appeals for the D.C. Circuit, and it recently upheld such a ban in D.C. The court assumed that the weapons were in common use, but that the ban imposed no real burden on people's ability to have a firearm for self-defense. A similar analysis would apply to a restriction on high-capacity magazines, which we treat separately than an assault weapons ban. Would a ban on the sale of high-capacity magazines, magazines capable of holding more than 10 rounds of ammunition, be constitutional? I think it's a similar analysis as the assault weapons ban. Are they in common use? Are they in common use for self-defense? That same D.C. Circuit case that upheld the assault weapons ban upheld a restriction on the sale of high-capacity magazines as well. The court said, yes, they're probably in common use. Again, there are millions and millions of these high-capacity magazines out there. However, the court said that self-defense typically does not require more than 10 rounds of ammunition. And there remains issues of fit, whether this substantially furthers the governmental interest given the large number of high-capacity magazines already out there. On the other hand, recent data suggests that the 1994 ban did have an impact, that the rate at which high-capacity magazines were recovered from crime guns appears to have dropped considerably in the wake of that law, and then increased dramatically after the law was expired. In my book, Gunfight, I try to show that there's a long history and tradition of gun control in America. Gun control is not the modern 20th century invention that many in the gun rights community tell us. The right to keep and bear arms has not historically been thought to be a significant limit on reasonable gun control laws, short of disarmament. And today, the major impediment to effective gun control laws remains Congress, not the Supreme Court. The court has made clear that many forms of gun control, including, most likely, the various proposals being considered in Washington today, do not offend the Second Amendment. Thank you.
Thank you, Professor Winkler, very much. Okay, so for our last presentation of the day, we have Dr. Colleen Barry. Dr. Barry is an associate professor and associate chair of the Department of Health Policy and Management, and she'll be talking about an exciting new public opinion poll that we recently commissioned that obviously is very relevant for understanding public support for many of the different proposals we've discussed today. Dr. Barry.
Good morning. First of all, I want to say that in the context of this summit, it is an honor to say that I'm a faculty member here at Johns Hopkins and a member of this extraordinary community. Before I begin, the title of my talk, of course, is Public Opinion on Proposals to Strengthen U.S. Gun Laws, and I want to acknowledge my wonderful collaborators on this work. I think nobody in this room or maybe on the Johns Hopkins campus at this point is unfamiliar with my collaborators, Daniel Webster and Jan Vernick, who have done such fabulous work in the context of this entire summit, but also the work on this specific study that was done in a very short turnaround time frame, as you will see. And many of you might not know Emma Beth McGinty, who is emblematic of the kinds of students that we have here at Johns Hopkins. Beth is extraordinary. She is a fourth-year doctoral student in our PhD program, and I think it's fair to say that without Beth's talents and involvement with this project, it would not have occurred. So thank you, Beth. So I think that I may be the only speaker presenting research here who is not an expert on gun policy and gun violence. My expertise is rather in health policy, in particular mental health and substance use policy, which is not unrelated to some of the events we've been talking about today. But I also spend a lot of time thinking about and conducting public opinion research and have interest in research methods. And so that's the context in which I became involved with the work of this summit. And I think that the thing that caught my attention in the weeks following the Sandy Hook tragedy was that as we saw public opinion data come out on this, the majority of the polling research that was done was asking questions about general attitudes among the public. That is, does the public support stricter or non-strict, less strict gun laws, those kinds of questions, attitudes about perceptions about the NRA, and relatively little information in the early weeks, no information about Americans' attitudes about and support for specific policy proposals. And I think that in this really fast-paced environment of policy deliberations over this issue, it's critical to understand how the public thinks about specific proposals to strengthen gun laws. We live in a democracy. We should care about what our public thinks, and we should bring the best research methods available to bear on identifying how the level of support in the population overall, but then also to understand how support may vary across important subgroups across our societies. So this is what we did. We tried to, we designed a survey data collection instrument to determine support for 33 policies among Americans overall by gun ownership and stratified by political party identification. And to look at gun ownership, most of the survey work that's done is your typical 1,000-person poll, and it's hard to get precise estimates using that approach for smaller subgroups within a public opinion poll. So in our survey, we substantially oversampled both gun owners and non-gun owners living in households with guns. We basically designed the survey on Christmas. There's no way to describe it in any other nice way, and we apologize to our family members that this occurred as it did. We'll make it up next year. So the survey was designed between the 24th and 27th. We pilot tested it. We programmed it up. We got it in the field on January 2nd. This is just-in-time public health research here. We pulled it from the field yesterday with a 69% completion rate or response rate. And what I'm going to present here is preliminary data based on a 61% response rate. And there is basically, it's an interim data set, but the results don't change based on the additional, at that point in the sort of distribution of responses, you don't see big changes. So I don't think the results will differ when we do the final analysis by more than a percentage point. The survey firm that did this for us is the wonderful GFK Knowledge Network survey research firm that does a ton of work across academic disciplines, and they've been a great partner for us in doing this over a very short time frame, so I want to thank and acknowledge them. They have a probability-based, very large web panel, which is a great answer in the current environment to some of the serious challenges related to conducting telephone survey research. So our results related to the share of gun owners in the U.S. are extremely consistent with recent data reported elsewhere. Within a percentage point of the General Social Survey, we see that in our data, 33% of Americans reported having a gun in their home or their garage, and that breaks down into two groups. 22% of Americans personally identify as gun owners, and 11% of Americans identify as non-gun owners living in a household with a gun. That means that the balance, 67% of Americans identify as non-gun owners living in non-gun households. And so as I run through these data, I will stratify by these groups. So just to give you a sense of the proportions. Now, on this slide, I'm going to give you a really quick rundown of the major findings of the survey, and then I'm going to get into the data. So we find that a majority of Americans support most of the 33 gun policies, including a ban on the sale of assault weapons, a ban on the sale of large-capacity magazines, a range of measures to prohibit potentially dangerous persons from having guns, a range of measures to strengthen background checks, a range of measures to improve oversight of gun dealers. Only 5 of the 33 policies were supported by less than a majority of the American public. For quite a few policies, the views of non-gun owners living in households with guns were actually more aligned with other non-gun owners than with gun owners. And for many of these policies, the differences between gun and non-gun owners were smaller than might have been expected. For me, as somebody that hasn't spent my career working in this area, they were smaller than I anticipated that they would have been. So before I jump into the results, we have 33 policies here. There's a ton of data. Hold on tight. Listen carefully. I'm going to go through a lot of information. This is extraordinarily interesting information, and I'm going to talk really fast, so bear with me. Okay, so everything is described in terms of percent favor or percent support. These are the assault weapons and ammunition policies. Over 65% in support of the ban of sale of assault weapons, the ban of the sale of large capacity ammunition magazines that allow guns to shoot more than 10 bullets and more than 20 bullets. I want to point out that almost majority, near majority, or majority support for these policies among gun owners. And this slide actually illustrates a really interesting thing that we saw in these data more generally, which is a big difference in percent support among gun owners overall and gun owners who identify as NRA members, which you can see from these data on these 3 specific sales policies report very low levels of support for these policies. We also asked about possession of assault weapons, possession of the large capacity magazines, and you can see somewhat lower level of support, although still over a majority in the American population as a whole for both of these policies in the context, and we heard about this some this morning, of a policy where the government is required to pay gun owners the fair market value of their weapons. Here are the assault weapon and ammunition policies broken down by Republicans, Independents, and Democrats. And you can see from my line that for the first 3 policies that I talked about, the sales policies for a weapon, the assault weapon and 2 magazine policies, over 50% of Republicans, Democrats, and Independents support these policies. Here are the prohibited persons policies, and you can see, and this first line illustrates this, very broad support among gun owners and non-gun owners alike for these policies, which include prohibiting a person convicted of 2 or more crimes involving alcohol and drugs from having a gun, convicted of violating a domestic violence restraining order, a serious crime as a juvenile, being on a terrorist watch list, even for the policy that Daniel talked about yesterday, which is prohibiting a person under the age of 21 from having a handgun, over 50% of support among gun owners and among others. Here are some policies related to misdemeanor convictions, and you can see that gun owners and non-gun owners are actually alike in terms of which policies they like the least. And these are particularly 2 types of misdemeanors related to drunken disorderly conduct being the basis for denying a gun, or indecent exposure, very low levels of support across the board. Here are the breakdowns by political party identification, and with the exception of the 2 misdemeanor policies I just described, high levels of support among Republicans, Independents, and Democrats for all of these policies. Here are the policies related to background checks. The first policy is the universal background check. Very high levels of support among non-gun owners and gun owners alike, even majority support among NRA members who are gun owners for this policy, as well as high levels of support for these other specific policies related to background checks. And very high support across political party identification as well for the universal background check policy, as well as the other policies. Here are the policies affecting gun dealers. You can see that these policies have, and I'm going to particularly point out this result, high support for all of these policies, majority support among gun owners and near majority or majority support among NRA members. I'm not going to go through all of these policies because I'm talking really quickly right now, but one example is requiring a mandatory minimum sentence of 2 years in prison for a person convicted of knowingly selling a gun to someone who cannot legally have a gun. Here are these policies in terms of the breakdown by political party identification. Here are the policies affecting those with mental illness. The first 3 policies are background check related policies. We've heard a lot about these policies over the last 2 days, and you can see very high levels of support across the board for these policies, including among gun owners and among NRA members who are gun owners. Lowest levels of support for a policy allowing people who've lost the right to have a gun due to mental illness to have that right restored if they're determined not to be dangerous. This type of restoration policy, which many of us know about, is not supported at high levels by any of these subgroups. Overmajority and high levels of support for a policy to increase government spending on mental health screening and treatment as a strategy to reduce gun violence. Majority support across the board. Here is the breakdown of these policies by political party identification. You can see that the top 3 background check policies are supported at high levels by Republicans, Independents, and Democrats, that the petition to regain gun rights has low levels of support among all 3. And for the policy to increase government spending on mental health treatment, a little bit more of a political gradient here, slightly less than a majority of Republicans support this policy. Although it's worth noting that any question, and this is why question wording is so critical when you do survey research, that includes the phrase government funding for, is going to tap into our views as citizens about what the role of government should be. So that is a component of how we should think about the response to that question as well. Here are the last 3 gun policies we looked at. Requiring a person to obtain a license from a local law enforcement agency before buying a gun has high levels of support across the board, including majority support among gun owners. Moderate support for a policy to provide government funding for research to develop smart gun technology, although, again, the same caveat in terms of using the concept of government funding there. We learned from our talk yesterday that there are ways beyond government funding per se to increase adoption of smart gun technology. Here is the policy requiring by law that a person lock up the guns in their home when not in use to prevent handling by kids without adult supervision. And you can see a gradient of support and some difference in opinion, as might be expected on this policy by gun ownership status. And here are these 3 policies in terms of majority support by political party identification. Okay. So what can we conclude from this research? First of all, number 1, we find high support among, including among gun owners, for a wide range of gun policies. And the most feasible policies from a political perspective include 20 from this list of 33 with majority support regardless of gun ownership or political party identification. So I think the bottom line from this study is that policymakers have a large range of options for curbing gun violence to choose from, which are supported by the American public. And I can't emphasize this point enough in the context of the discussions that we've been having over the last couple of days related to the fact that there are multiple levels of problems here, and that speaks to the need for a more combined and comprehensive approach, and this research suggests that that kind of approach would be supported by the American public. Thank you very much for your time. And I should say, for detailed information on the findings, check out the book in 2 weeks.
So thank you, Colleen. And yes, this was an enormously quick effort to produce what we hope are powerful polling results. They're also going to a peer-reviewed journal very, very quickly as well. So Daniel tells me that we can invade about 10 minutes of his concluding remarks with questions for with questions for this panel. So are there questions? Yes, Steve. Is the microphone? I know that C-SPAN is still streaming today. Maybe the microphones have gone away.
Here, borrow mine.
Here comes one.
It's a comment.
Can you raise your voice at the end?
Yeah, it's a comment, but I'll hide it. I'll hide it as a question.
Okay.
A question, and it's directed to Dr. Barry, and it's prefaced by a wow, what a great piece of work. That I don't mean you, great piece of work. I mean that too. I mean the research.
So
Colleen,
only with
thank you.
tenure can you say things like that.
Yeah. So you mentioned the importance of language, and obviously I have a stake and an interest in the question that dealt with personalized guns and whether you approve government funding. And I appreciate your commenting that the response may be influenced by the preface of government funding. There's another thing that influenced the response. When we did surveys in
Around 2000.
a little after 2000, we did a series of 4 waves of random digit dial surveys, with each wave encompassing 1,200 representative adults, a representative of the American population. And we asked questions about personalized guns, but we asked them in 2 ways. We asked it about personalized guns, and we asked it about childproof guns. And again, I use those synonymously, and for example, the state of New Jersey used them synonymously when it passed its law. We found a substantial difference, though, in the answers that we got, whether it was personalized. So when we asked people, would you favor a law requiring all new guns to be personalized, with a little explanation of what that was of the general population, my recollection is that it was in the mid-60s. When we asked the same question with regard to child-proof guns of the general population, it was 88%. When we teased out the gun owners from that, it was still 81%. So how we spin the question or phrase the question, I think, is going to be very important.
Can you hear me? I want to make a quick comment on this. Thank you, Steve. Those are wonderful, extremely important points. And I will say, as somebody that, again, has not spent my career in this area, and I went to the research literature to find out what the prior polls said, I was frankly astonished that the last major publication on public opinion research was from 1998, first author Steve Terrett, so long ago. We need more up-to-date, more research on public attitudes about this issue done in using scholarly research methods. And I, in particular, because we were doing this in such a short time frame, and I was pissing off my family members because of the timeline, we were not able to include all the questions that we would have. And there are many questions in that original Terrett study that weren't asked in the study, and that study should certainly be replicated now, I think. Thank you, Steve.
Yes, ma'am?
Good morning, Dr. Duval Harvey, Deputy Commissioner, Baltimore City Health Department. I'm glad that at the end we find that Americans are reasonable people.
Can you speak into the microphone? Thank you.
But I want to ask a question about a subgroup that you haven't talked about, and those are the reasonable people who get firearms for the purpose of protection in their home. Is there any evidence that suggests that this makes sense or not? So is someone invading their home with a weapon? If there is a weapon in the home, to retaliate? Are people successfully addressing, home invasion in this way? What is the evidence around self-defense in the home?
I'll just very briefly respond to that, but actually David Hemingway, if he's around, might want to also contribute to this. David is over here. So generally speaking, the data, whether you're talking about a case control household type of study design or a more ecological examination of places where there are more guns versus less guns generally, again, show a relationship where there are more guns, there's more death, including homicide, and that those self-defense type of opportunities are pretty rare. David Hemingway has demonstrated to us very well why we should be quite skeptical, at least, of some surveys of self-defense, because it's easy to be prone to exaggeration about sort of what the nature of those incidents were. And David, I don't know, I just want to give you an opportunity if you want to.
Let me just mention that Dr. David Hemingway is a professor at the Harvard School of Public Health and has done lots and lots of work on gun violence prevention generally, but on the risks and benefits of gun ownership. Do you have? I don't know if you have a microphone available, but it looks like it's coming. It's coming down here for you.
Hi. So what Daniel said is correct. Is that the evidence really indicates that a gun in the home is a large risk factor for suicide in the home, a completed suicide. Clearly for a gun accident, and also for femicide. It's really dangerous for a woman. There's not as much evidence about a man in the home and a gun. The evidence indicates that a gun in the home is much more often to be used to intimidate somebody in the home than to protect yourself against some intruder. So for most people, it really looks like the evidence is pretty strong that it's not a wise choice to have a gun in the home in terms of public health. I have a question for Adam, though, which is from one of the long comments in the previous section. Is can you talk about the Second Amendment and this notion of having a gun to protect us against a totalitarian dictatorship that may take over, and we require the gun owners to overthrow that government?
That's right. This has been a common view of the Second Amendment among some in the gun rights community, and they largely base that idea on some words of the founders. The truth is the founders were revolutionaries who thought to protect their guns as a way of fighting against government tyranny, but largely divorced from our current Constitution and how it's understood. The Supreme Court in the Heller case said that the core right protected by the Second Amendment was the right of self-defense, a right to have a functional firearm in your home. And indeed, if you think about civilian possession of firearms, it is the world is obviously vastly different than it was in 1791. The framers were afraid of a standing army. We have a standing army today, and I think that many people who support this sort of insurrectionist view of the Second Amendment were disappointed that the Supreme Court, in its Heller decision in 2008, did not give voice to this more anti-government view of the Second Amendment. The truth of this is the Second Amendment clearly envisions a well-regulated militia. Whether the Founding Fathers thought that it was important to have civilian gun ownership as a deterrent for tyranny, the Second Amendment itself clearly envisioned government regulation of the militia. The Supreme Court said that when the framers referred to the militia in the Second Amendment, they were referring to common citizens, the body of citizens capable of coming out and ready to grab their guns at home and be ready to fight in an instant. But that militia would be well regulated by the government. And indeed, the Founding Fathers had extensive militia laws that required people to show up at mandatory musters with their guns in tow, where they and their guns would be inspected and even registered on public rolls. And indeed, for all the controversy over President Obama's health care mandate that got so much attention in June of last year, the Founding Fathers in 1792 passed a law requiring every free citizen, free male between the ages of 18 and 45 to outfit themselves with a rifle, a military-style firearm for a military-style musket for capable of serving in the militia. So the Founding Fathers did not view the Second Amendment as a basis for insurrection. Rather, they viewed it as part of a well-regulated militia.
Thank you. Yes, ma'am.
Thanks. Melissa Lindemood from Government Affairs here at Hopkins. I was wondering, Dr. Barry, if you could talk a little bit about whether in the publication you might be able to stratify or break out likely voters, just thinking about polls that policymakers are going to be really paying attention to, whether that's one way, a hook, and then also, so likely voters and also by state or region of the country.
Yeah, those are good questions. As we know, often in the context of election polling, survey research firms have proprietary algorithms, usually 4, 5, 6 questions that allow them to break out likely voters. Our goal and our motivation for this research was something different. We, for this purpose, care about the views of all Americans, and so we wanted to report the rates of support among Americans, broadly speaking. And so we didn't ask that likely voter battery to be able to subset the data. There are other, I think, important ways once we have time to further analyze the data beyond what will appear in the chapter that may be of interest in terms of subgroups. Region of the country is important, although correlated with gun ownership. So, you know, that has to be done with some care. Parents versus non-parents. We talked a little bit about how age matters on this issue. And so just being here in a university context, I think it's important to understand how younger people versus older people think about issues related to gun violence to see whether there are generational effects here. And that gives us some insight into where we're going as a country as younger people become older and have more of an ability to influence the political process. But yes, great point. Critical to understand these data in terms of various different types of subgroups that matter. Thank you.
Well, I know there are many more questions, but I want to make sure. You want to take one more? All right. Where's the microphone? Okay, yes, sir.
James Pear, Trident Security Training. I'd like to thank all of the speakers for the wonderful information that has been brought forth. But I would like to say that I would have expected more talk on the impact, the important impact of training on the effectively reducing gun violence. So for law enforcement personnel, for ex-military personnel, for the average citizen, in our schools, businesses, training is the glue that holds together all of the measures that we've been discussing yesterday and today.
Okay, thank you, sir. Daniel, would you like to respond to that?
Sure, maybe I'll do that, and I'll just.
Sure.
I would just have one brief comment to say.
Go ahead.
That thank you, Professor Winkler, probably correctly said that defense by a gun in the home is a rare event. That may be true. Nonetheless, it's a very important effect for those who have actually been affected by it. So I'll end that with the importance of training. Thank you.
Sure. Thank you. Thank you for your comments. Well, I just want to wrap up with some reflections on what's really has been an amazing couple of days here. I'll start with the thanks to what a fabulous group of contributors that we have to this this event. Jan and I sought out to really get the absolute best minds available to tackle what is obviously a very complex problem. If you just look at just understanding gun violence by itself, that's a struggle. If you start to think about the policy challenges, that's a whole another struggle. And level of complexity. You have the legal issues, and then all the political things we've been talking about. And I really feel like we were successful in bringing the right people together to address that. And I feel very, very good about that. I also feel confident that this will actually lead to productive solutions to address one of our most important public health problems. Prior to the Sandy Hook Elementary School shooting, we'd already had a really terrible year with mass shootings. And I, for one, was particularly frustrated following those events, the level of discourse that occurred, mostly in the media, very formulaic kinds of things. And the messages that I felt were getting through were really quite inaccurate. The message was there's great disagreement among Americans about gun control, that nobody really wants gun control. We can't do anything because of the Second Amendment. There are no gun laws that work. All of these things we've found, with the best evidence and the best people, to be false. We can go forward. We do have data. We do have very good ideas about how to address a very important problem. I don't underestimate the challenges on any dimensions. Again, this is a very complex problem, particularly the political aspect to it. But I think the contributions, particularly our last panel, give me, and I suspect many here, a level of optimism that we're at a different place right now. Our country's at a different place. And I think we do have things that can work. I was very inspired by our panelists this morning by how in Australia and Brazil and Scotland, they responded, and it wasn't easy. And I particularly am so impressed with the efforts in Brazil, knowing the sort of obstacles that were in front of them there. So I leave here with great optimism that we're in a different place now, and we can make meaningful change. I want everyone to know sort of what comes next. You've heard that we will be coming out with a book published by Johns Hopkins University Press within less than 2 weeks, I believe. Every effort will be made to make that available to the relevant policymakers and, of course, the general public. One final thing I wanted to say, you know, I've been thanking the contributors, but I want to also just thank the Johns Hopkins community here. It's been just tremendous to see the level of interest and really deep felt commitment to address this problem by so many people who don't necessarily work on this. It's not their careers. They have other important things they're working on in public health or in other areas. And I for one, have just been felt really supported by that. And I think that's it. Let's go out and actually make some change.